Hey, I'm Divya Bhaktha from Outlier Compliance Group. Today, let's understand what should be done after reporting suspicious transactions to FINTRAC. The reason we decided to do this presentation is because of what we have observed in some of the recent FINTRAC penalties, specifically in relation to not reporting subsequent suspicious transactions, where you have decided to maintain the business relationship or continue to conduct transactions for a client to know whom an STR has been filed. So let's begin with what should you do after submitting a suspicious transactions report to FINTRAC. Well, if you continue with the business relationship, the client should at a minimum be rated as high risk. The client should be placed on enhanced monitoring. Subsequent STRs must be submitted if the pattern continues or if further additional red flags are identified. If you discontinue with the business relationship immediately after filing an STR, the client records and copies of submitted STR should be maintained for 5 years from the day the business relationship ends. A business relationship ends 5 years after the day on which the client closes their last account with you, or when a period of at least 5 years has passed since the day of the last transaction that required you to verify the identity of the client. As such, to ensure the client records reflect the actual risk of the client before exiting the business relationship, the client's risk at a minimum should be elevated to high. What is the need to report subsequent suspicious transaction reports? Well, the failure to submit STRs or subsequent STRs hinders FINTRAC's ability to analyze transactions, share intelligence, identify money laundering and terrorist financing risks, and raise public awareness, undermining its mandate under the Act. What happens if subsequent suspicious transaction reports are not filed? There's risk of substantial monetary penalty. The penalty, not considering the mitigating factors, is $250,000. Also, there's reputational risk. FINTRAC considers it as hindering the investigation and prosecution of money laundering and terrorist financing. FINTRAC, as mentioned earlier, FINTRAC considers it as severe non-compliance, and it falls under the category of very serious violations. One of the most recent administrative penalty levied by FINTRAC on May 29th indicated failure to submit subsequent suspicious transaction reports as one of the violations. It was found that the transaction pattern of the reported suspicious transactions continued, but the entity did not submit subsequent transactions report. So, remember that if suspicious transaction pattern of a client on whom an STR has been submitted continues or additional red flags are identified, subsequent STRs must be submitted. Also, remember to reference the original STRs while submitting subsequent STRs. Remember to explicitly indicate the reporting of subsequent STRs in your AML program document to ensure that it is implemented. I have provided a very brief explanation regarding filing or the submission of subsequent STRs. If you have any questions regarding this or related topics, please reach out to us at the given email ID. You can refer to the links given here if you want to understand more about the administrative monetary penalties or reporting suspicious transaction to FINTRAC, or if you want to understand more or need to refer to a guide on harm done assessment for suspicious transaction reports violation. Thank you.